ಮುಂದೆ ಬನ್ನಿ, ಅಷ್ಟಿಂದ ಕುತ್ಕೊಂಡಿದ್ದೀರ. ಏನ್ರಪ್ಪ ಎಲ್ಲೋ ಆನ್ಲೈನ್ ಅವ್ರಿಗೆ ಕೇಳ್ತಾ ಇದ್ರಿ, ಆನ್ಲೈನ್ ಇದ್ದವ್ರಿಗೆ. ಬರ್ತೀನಿ, ವೆನ್ ಯು ಆರ್ ಕಮಿಂಗ್ ಬ್ಯಾಕ್. Okay. So answer last class. What is the answer? ನೋಡ್ಕೊಂಡು ಹೇಳ್ಬಿಡಿ ಸೈಡ್ ಗಿಡಿ ಆರಾಮಾಗಿ ಹೇಳಿ. ಪೊಲಿಟಿಕಲ್ ಡಿಸ್ಪ್ಯೂಟ್ಸ್ ಕೋರ್ಟ್ ಹೋಗೋದೇ ಡಿಸ್ಪ್ಯೂಟ್ಗೆ. ಕಮರ್ಷಿಯಲ್. ಎಸ್ 3 ಸ್ಟೇಟ್ ಹೋಗ್ಬೋದಾ? ದೆನ್ ಆಯ್ತಲ್ಲ. ಓಕೆ, ಇಷ್ಟಕ್ಕೆ ಹೋಗೋ ಹಾಗಿಲ್ಲ. ನೆಕ್ಸ್ಟ್ ರಿಟ್ jurisdiction. Okay.
There are 5 types of habeas corpus.
Mandamus, certiorari, and quo warranto.
Fundamental rights.
Federal disputes with fundamental rights. Then so both Supreme Court and High Court can handle writ jurisdiction. Then states and center. What are then here? State government.
Constitution matters, civil matters, and criminal matters. Constitution matter, civil matter, High Court certificate important.
ಎಲ್ಲದಕ್ಕೂ ಸರ್ಟಿಫಿಕೇಶನ್ ಎಕ್ಸೆಪ್ಷನ್ ಕ್ರಿಮಿನಲ್ ಅಲ್ಲಿದೆ. ಸೊ ಸರ್ಟಿಫಿಕೇಶನ್ ಆಫ್ ಹೈ ಕೋರ್ಟ್ ಇಸ್ ರಿಕ್ವೈರ್ಡ್ ಫಾರ್ ವಾಟ್? To appeal before Supreme Court. Without the High Court's certification, it cannot be taken. But for criminal, especially when the reversal of death sentence, no certificate is required. Then yes.
It can be related to any matters, constitution, civil, criminal, income tax, labor, revenue.
ಏನದು? Don't read it out. What is that?
Totally petition on any matter.
So on any matter, you can go to Supreme Court as a appeal. But the difference is, it is not the right. But Supreme Court can reject, means may not accept. Only Supreme Court is having power. I don't want to accept means no, you cannot question. Then so now the next one is advisory jurisdiction. Monday onwards, first revision will be done by only online students. Okay. Next is advisory jurisdiction. So what is advisory jurisdiction? So it's saying that advice. Who is getting advice here? Court advice. ಅವರೇ ನಿಮ್ಮ ಹತ್ರ ಕೇಳ್ತಾರ ಬಂದು. Polity students ಬಹಳ ತಿಳ್ಕೊಂಡಿದ್ದೀರಿ. You only take advice of the Supreme Court ಬಂದ್ಬಿಟ್ಟು ನಿಮ್ಮನ್ನ ಕೇಳುತ್ತೆ. ಯಾರಿಗೆ? Who will get advice here? Supreme Court advice ತಗೊಳುತ್ತಾ?
President will seek.
Yes, government ಅಥವಾ president. They will means they have doubt. Why Supreme Court will have doubt? They have the interpretation capacities and their decision is final. Why they will have doubt? Right? See, if Supreme Court is having doubt, they themselves decide. But government is having doubt means they will ask Supreme Court. Okay. So that is advisory jurisdiction. They are asking advice of the Supreme Court. On what matter they will ask advice? Yes. We want to make a law. Please help us. Is this law correct? Is this law okay? Correct. Second is, we have some problem with respect to pre-constitutional treaties, laws, conventions. Before independence, they have made some agreement. We cannot escape from that, right? We are also living in the same area and we are supposed to handle it. So what to do with respect to that? Some king might have given for the next 999 years. So this is to you. So can we obey that now? They might have given. Can you, what is our role here? Oh, the government is having some dilemma. So, yeah. Okay. So that is asked under Article 143 of the Constitution. So Article 143. Who asks advice? President asks advice. With whom they ask the advice? With Supreme Court. Actually, personally, who will take this case? Attorney General. Attorney General is like a liar. President will not go to Supreme Court. He will ask his lawyer. Actually, government asks President. President asks Attorney General. Attorney General go to Supreme Court. Okay. Obviously, on behalf of government only. So, as I said, there are two categories. One is on any question of law or fact of public importance, which has arisen or likely to arise. Here they will ask the question. Which has arisen. Got it? Already it is in dispute. Or they are thinking that it may come in future. So before that itself as a precaution. And second thing, as I said, pre-constitution treaty agreement, covenant, engagement, whatever, before whatever name they have given, but it is some sort of law only. But before constitution, see, after constitution, obviously this is different scenario. Everything is under our control. But before constitution, some problems may arise. How to handle that? Okay. So in which case, so now option number one with respect to Supreme Court, giving advice. Correct? Second option is saying, no, I don't want to give advice. Can Supreme Court say no when they ask advice? When? See, for this A option, that is, it can say no, I don't want to give my advice. But for B, it cannot say no. Means it must give its advice. Because government will ask, if you are not giving advice, with whom we have to ask? We don't have option. But option A, it may say no, whatever reason. But later also, at will Supreme Court will tell what you have done is wrong. But on part B, so it must give. They will ask this one only in the exam. So in the first case, Supreme Court may refuse it. Okay. But in second case, it cannot say so. Okay, fine. Now, see here. Now, always remember, like, you write the diagram to understand. So, President is asking Supreme Court under Article 143. That is, AG will go and ask. Now, this part is over. What are the options with respect to Supreme Court? For one, it may say, no, I will not give. For a second one, it must give its advice. Okay, anyway, Supreme Court part is over now. So if it says no, then there is no question of returning. Means there is nothing in the hands of government. Suppose it has given its advice. What government has to do? Option A, it must accept its advice. It is binding. It can reject and go ahead like what it wants to do. Ishadanka ilinda aligoytu letter, right? So letter is moving from Parliament or means President to Supreme Court. Now the role of Supreme Court is over. It has given its advice. Now again AG is having that letter. Okay. So President is sending love letter to Supreme Court. Supreme Court has given its answer back to Parliament. Now whether it must accept or it can also reject that advice. It can also reject. Sorry, Parliament only said I love you, no, then it must accept. Because why they are asking my advice if they are not going to accept? It is up to them. It's up to them. Okay. It's up to them. So they are asking, means sending love letter. So girl is saying yes, but my father said that will not given 1 rupee of my property. So he may change his mind. He may change his mind. Anyway, means again, it is, they have taken advice. It is not necessary that they must accept it. Okay. See, this is why I am highlighting this. Usually whatever Supreme Court says, that is final, binding. But in this case, this is just an advice. It is not a judgment. It is not a judgment. So if it is a judgment, it is binding on everyone, not only on President. If it is judgment, means throughout India, everyone must accept it. It is not a judgment, so it is not binding. Okay. Till now, like this 15 times he has asked. Okay. Sometimes people call it as also consultative. So he's consulting. Don't get confused. What is this new word? So advisory, consultative jurisdiction. They are consulting. So examples like during Kerala Education Bill, they asked, this is a place. They wanted to hand over it to Pakistan when we separated, no? So after that, it came into litigation in 1961, I guess, 60. Okay. So government wanted to hand over Berubari to Pakistan. So they asked Supreme Court, what will happen? Whether is it legal or what, any problem will happen. So like that it asked, and finally asked after the advice, the place was handed over to Pakistan. One example at least you must remember, then only. For some things, no need of example. That is like thousands of examples you'll get. For some things you must remember examples. Okay. Next is court of record. What is court of record? This is very simple. Court of record means it is like a constitution itself, I can say. Whatever is written in constitution, everyone must follow. The same way, if a Supreme Court judgment is delivered, that is as good as constitution. Actually, practically, I said it is more than somewhat constitution. We cannot say that officially, but in reality, that is the truth. Because constitution don't have mouth. Whatever Supreme Court says, the interpretation of constitution, the line in the article 143 is like this, means who will tell that? Yeah, it's a case law. She rightly said that is constitutional law. See, we have different laws in country. One is a constitutional law. Constitutional means whatever constitutional says, that is the law. Another is a statutory law. Whatever parliament makes, that is the law. This is case law. What is case law? Case has happened and it has become like a law. So everyone must follow that. So constitutional law, statutory law, and case law. Is it clear? All are having equal effect only. Implementation wise, all are same. Maybe removal of this may be difficult. This one is somewhat difficult. This one is somewhat easy. But implementation wise, 100% all are equal. The constitution has written, or parliament has made law, or Supreme Court judgment is given. This is of higher value, this is of lower value. I will only listen to constitutional. No, you must listen to everything. For example, whether Supreme Court says for children, you must give reservation. Whether Parliament says you must give reservation. Whether Supreme Court says you must give reservation. No difference at all. No difference at all. Is it clear? So, court of record means the judgment of the court. That's it. How powerful, for example? For example, suppose in Supreme Court. In Supreme Court, for example, if you say, take the talaq example. Okay, so that is not like a valid ground of divorce, talaq. Since how many years they were practicing that? From, yes, means very long time, correct? No? So for thousands of years, means since from the like almost 1,000 years, you can say. Once the verdict is over, now if somebody gives talaq like that, nobody will, means the law will not permit that, correct? No? So after the judgment, suppose somebody is making law related to talaq or somebody is giving talaq like that, it is in 1 second, they can say that, no, this is wrong, not going to accept. That much powerful it is, that's what I'm saying. Judgment is also like constitution. Right? So it's means it's having two powers. This is like court of record means in suppose a similar case comes in High Court of any state. Simply they will say court this case. So now onwards, as per the so and so case, so this is null and void. Immediately they will deliver the justice. For example, first decision might have taken 1 year, 2 year, 3 year, 4 year. But now the decision will be done in just in one hearing. Why? Because this is similar case to what has happened in Supreme Court. Now no need of doing all like listening to your point or their point. No. This is similar case. So judgment can be delivered easily. That's why it's called as court of record. It's a record. How the constitution is a record. This is a court of record. So judgments, proceedings and acts of the Supreme Court are recorded and cannot be questioned when produced before any perpetual memory and testimony. If somebody says that so and so case of Supreme Court says like this, means you cannot question why you have to accept that case. No, you must accept. That is like a evidence. That is like a evidence. Okay, testimony. So you must accept it. They are admitted to be of evidentiary value. That's what how a person comes and tells his evidence. No, like gives evidence to a particular case. The same way this court judgment is helping to solve the case. They are recognized as a legal precedents and legal references. Different words are used. And second thing, if somebody is not following that word, contempt of court, for that he will be punished either with simple imprisonment up to 6 months or 2,000 fine or both. Okay. So not only for Supreme Court, for example, a person A is violating Supreme Court order. For him, what is the punishment? 6 months or 2000. Suppose a person is violating High Court order. Same thing. That's what. So not only of Supreme Court, High Court, about any court in India, if you are violating any court order, you are liable for punishment of 6 months or 2000 or both. Is it clear? Or the biggest power, that is power of judicial review. What is judicial review? Yes, single line I can say questioning power. What it questions? Given judgments. That will be option A. See, it is there to question government, their laws. It is not there to question itself. I am saying the main purpose of judicial review is questioning government. What it is questioning in the government? Their work, that is lawmaking. Lawmaking, correct? No? The judicial review is the power of Supreme Court to examine constitutionality of the legislative enactments and executive orders, both at the central and state level. So Parliament bringing a law and telling that 70% reservation will be given to backward people. Supreme Court questions that. You cannot cross 50%. This is wrong. Throw it to dustbin. Correct? No? So it is checking as per the constitution. So it is telling that for Maharaja of Mysore, we are giving governor post forever. Have you read constitution? Equality. You are breaking the rule of equality. So that law is wrong. So it is checking. It is always holding the constitution book, whether what you are doing is according to constitution or not. According to constitution or not. So keep on checking that. Okay. So not only of law, they are also questioning executive, correct? You people are also passing some order, right? For example, some ML house is there. So that is the one way. Nobody can come enter that. No, that is wrong. I will question that. On what basis you are doing that? So executive order also I will question. Because you are also liable. So whether it is a law or means legislature body or executive, I will question them. That is my birthright. So whom I am questioning? Only central government? Anyone. Central also I will question, state also I will question. It is my birthright. Questioning is my birthright. Okay. So that is the power of judicial. Very, very powerful. So many examples are there. Okay. And Supreme Court has thrown it to dustbin. Mainly reservation bills. Many times. Again, one more example will come from Karnataka. Now they have given 66% reservation. Again, in future, again that will throw it. This is wrong. You cannot cross 50%. Many reservation bills, not only reservation bills, many bills are thrown to dustbin. Okay. Many times Parliament has tried to amend the constitution. So Supreme Court is using its gun. What is the gun name? Judicial review. Same. Parliament is having one powerful gun. What is that? Amendment. Correct? No? That is biggest power. I will change the constitution itself. You change, I will shoot it down. So both are having gun. Okay. That's what. If this makes wrong, I will change it. Amendment. If government makes wrong, I will shoot it down. So both are having powerful guns. The government gun is amendment. Judicial gun. I can question anything. Okay. So even if sometimes Parliament makes, you are not, no one can question this law. Like that they have written many times. Supreme Court comes and who are you to tell like that? Remove that line first. I will question. I will allow your law, but I will not allow this line. Artha agtidea? For example, you ask money to father. You should not ask for what I am spending this money? Father says, take this money, but I'll slap you if you say that. Don't question me for what I'm using this. That is my birthright. So Parliament, yes, you do the law, no problem. But don't say that, don't question me. That is my birthright. Is it clear? So that is a judicial review. So decide disputes regarding the election of the president. Oh, that is other powers we came, no? Is it clear? Judicial review? Very, very powerful. Election of president and vice president, any dispute means Supreme Court will handle. We know that. Correct, no? And no other court can do. That's why this is original, exclusive, and final. It cannot take to any court. Second, means in other powers. Other powers are very, very important. Each line is one question. Remember that. See, this is one question. Who will handle the election cases of president and vice president? Supreme Court. Second, who handles UPSC chairman and members cases? Means if they are wrong, usually if somebody is wrong, who will remove them? Parliament. Means through president only, but through Parliament. But in case of UPSC and other members, only Supreme Court. Why Parliament is not involving here? If you want to remove president, Supreme Court. Sorry, Parliament. Vice President, Parliament. Want to remove election commissioner, Parliament. Remove judges, Parliament. But for UPSC, why it is not involving? This is second time I am asking. Online idda ಸ್ವಲ್ಪ ಬಾಯ್ ಬಿಡ್ರಪ್ಪ. Yes, independency. That is, politics should not interfere in the merit. If I start controlling them, I will remove him. Please select my candidate, otherwise I will remove him. So that should not happen. So merit-based agency should not be under the control of politics. Correct, no? That is the reason for UPSC. Who will decide? Supreme. President, they will send it to president. But the president don't have like a discretionary power. No, I will not accept this. He must sign. Is it clear? So, if the UPSC members or chairman are guilty of misbehavior, then Supreme Court may ask them to remove. Correct? And it is binding. If Supreme Court says, president must remove them. Third, other power. Third other power. So earlier you said, no, it is questioning itself. That is here. That is here. So it can change its own judgment. Many times it has happened. First judge, plate change. Second judge, plate change. Third judge. So it's correcting. That is good part. It is correcting itself. Usually this is called as curative petition. Suppose I'm not happy with your judgment, I will go for another, like I will question again. Curative means curing, solving that. So curative petition, it means it will not say like I am always right. Okay, 3 judges have decided, okay, 5 people will decide now. Next 7 people will decide. So that option is there. Any doubt in this? It corrects itself. Means it questions itself. But judicial review is not for this. Judicial review is for legislature and the executive. That's what? Law and orders of the executive. See, many times it has happened. Here, this case they are saying, no, we'll discuss in fundamental rights. But Champaka Dwararajan case, it said something. Then Shankari Prasad case, it said something. Next, in Golaknath case, again plate changed. In Keshavananda Bharati case, again plate changed. That means it corrected itself. I said like this, no, this is correct. Again change, no, that is correct. No, this is only correct. So it is correcting itself. Shankari Prasad, Golaknath, Keshavananda Bharati case. Okay. And next power. Suppose a case is running in High Court. Supreme Court can say that, please hand over the case to me. That power is there. Or High Court is running in Tamil Nadu. It can say, please hand over that case to Karnataka High Court. That power is there in the hands of Supreme Court. Why? For example, Jayalalitha case was handled by Karnataka High Court. Why? It is supposed to be held in Tamil Nadu, right? Because she is very powerful there. It leads to a lot of disturbance. So without disturbance, it is better to handle in Karnataka. So it is handed over to Karnataka. So Supreme Court is having that much power. Or it can say, please give that case to me only. Or you give it to other High Court. So whatever it says, that is also its power. And its law is binding on all courts. Yes, we know that. Not only for court, everywhere it is acceptable. Is it clear? So these are all powers, that is jurisdiction of the Supreme Court. Okay, fine. Now we'll discuss about advocates in Supreme Court. What are the different type of advocates? So what type of advocates you have seen? Senior advocate, junior advocate. Okay. So then who is this senior advocate? Not by just experience. If Supreme Court or High Court calls them as junior, senior, then only it is called as senior advocate. Just because a person is practicing for 20 years, he is not senior. Yeah, in the common man's eye, he is a senior. But if you want to call him officially as a senior advocate, okay, so Supreme Court or High Court must designate, yeah, he is senior. So, got it? And this senior advocate, no, he cannot directly file a case and appear before Supreme Court. Means he cannot simply go to the court and start. No, he cannot file the case. So that power is given to advocate on record. That means a senior advocate cannot go alone. If suppose they want to file a case, who has to file the case? Advocate on record. He can go and argue, but he cannot file. So that's what he is not allowed to appear without advocate on record in Supreme Court or without a junior in any other court or tribunal. So if you want to appear for a hearing, appear for like taking the case of some client, you cannot go alone. You must carry advocate on record. He will file the case. He will do everything. He can do his arguments. In Supreme Court, advocate on record is required. In High Courts, at least some junior lawyer should be there along with him. Either court, even in tribunal also. Is it clear? Advocate on record is essential to file the case. Senior cannot file the case, but he can go and argue. So, advocate on record, that's what they can only file any matter or document before the Supreme Court. Any document submission, whatever. And other than this, general advocates, like who are registered under Bar Council, no? So they can appear and argue any matter on behalf of a party. Means other lawyers can also. Is it clear? Fine. Now, in 5 minutes, we can finish off High Court. How? Because only comparison. Here we are. Again, we are not going to discuss. Just comparison is enough. So, like point-wise, 10 points. Where the difference is there, that only we'll discuss. Remaining all same. That means, like appointment, wherever changes are there, that we'll discuss. Is it fine? So, first difference. Supreme Court is an apex body for whole India. High Court is an apex body for states law and order, headed by Chief Justice of State. So easiest point, that is for whole India, this is for that state. Headed by Chief Justice of India, this is Chief Justice of Karnataka, Tamil Nadu, Madhya Pradesh. Is it clear? Second point. How many Supreme Courts are there? Only one. How correct now? Even don't have other places as the seat of Supreme Court. How many High Courts are there? Presently 25, I guess. 25 High Courts are there. Okay. But sir, we have more states and union territories along almost 35. Correct no? But less are there. For some states and union territory, combined High Courts are there. Please do homework for this. Questions will be asked. Got it? For example, Chandigarh, Haryana, and only one court is there. Correct? So, combined. Karnataka, we have independent. Kerala, we have independent. Okay? So, some states and union territories have single High Court.
Yeah.
That's what, mixing. Some states are attached with UTs. For Delhi, separate. Separate union territory, but separate High Court is there. Is it clear? Third point. Obviously, High Court enjoys superintendence over all courts under its jurisdiction. That means below High Court, District Court, Municipal Court. But how about Supreme Court? This is interesting. So High Court only has to look below. Okay? But for Supreme Court, not only below, it can side also it can look into. What is the meaning? Even tribunals also it can. Artha madkoli neatagi. High Court only looks what is below it. But Supreme Court not only looks about High Court, District Court, Municipal Court, but also about tribunals in the country. Not only courts, even tribunals comes under Supreme Court. But for High Court, only below courts. This is the third difference. Next, appointment. Who appoints the Supreme Court judges? President. Who appoints the High Court judges? Don't say governor. President only. But difference we are observing. See, President appoints judges of High Court, correct? But he will discuss with the Chief Justice of India, that we know. Always he does that. But here, governor. Because they are appointing judges to High Court, right? High Court of Karnataka, Madhya Pradesh, Uttar Pradesh, right? Now, one extra point is governor. Chief Justice of India, yes, we know that. Definitely they are going to ask. Doubt illa. Collegium. Okay? Any doubt? So difference mark that itself will be asked. In Lakshmikant, again, they discussed everything as a chapter, not necessary. We want only differences. Next, age of retirement for Supreme Court judges is for High Court. What is the logic? This is correct. What is the logic behind that? There is no logic actually. Yargaru answer correct ansta idu. Is there any logic for this? Online someone? ಮಾತಾಡ್ರಪ್ಪ ನವೀನ್ ಶುಭ ಶ್ವೇತಾ ವರ್ಧಿನಿ ಕಾವೇರಿ ಪಾಲಾಶ್ ಎಲ್ಲೋದ್ರು ಇಲ್ಲೇ ಇದಾರ ಎಸ್ no logic actually. If they can handle up to 65 years, these people can also handle up to 65. Okay, so actually there is no meaning to it. Simply they are taking 3 years of their tenure. Actually, they must change this. Next, sixth difference. Judges of High Court cannot plead before any court during their tenure and after retirement. Okay, they cannot plead in any court below High Court. But how about judges of Supreme Court? See, High Court judges, can they practice in Supreme Court after their retirement? Yes. See, this it may be big, but only one line. High Court judges, they can practice in Supreme Court, but they cannot practice below because influence. But Supreme Court judges, no option at all. Throughout country, they cannot plead anywhere. They cannot practice, ban on practice. You know the reason. Okay. Coming to difference in eligibility. Comparison. 7th comparison. So, for Supreme Court judges, what are the eligibility conditions? Okay.
Judge in
High Court,
High Court,
10 years in advocate, in High Court lawyer,
resident in the
DJ, distinguished jurist. So 3 options are there for as a eligibility to become Supreme Court judges. So what are the eligibilities to become High Court judges? Yes, that citizen of India, you leave it. Then, so here there are 3 options. Here 2 options. One is at least 10 years you must be holding a judicial office. They are not telling judge only. You are holding a 10 years judicial office, or again 10 years lawyer. Both are 10 only. Any judicial office 10 years, that means either a judge or anything, or 10 years lawyer. Is it clear? But in High Court only, don't assume for that it is High Court, for this district court. Here also High Court only. Now confusion al exam alla baradu. For Supreme Court, he must have practiced for 10 years in a High Court. For becoming a High Court judge, he must have practiced 7 years or 10 years in a district court. No. 100% mind hange odadalva. But here also High Court only. This condition is same for both. I am expecting that question. He'll write, if a person has worked as a lawyer in 2 or more High Courts for 10 years, he is eligible for both Supreme Court and High Court judge posts. Correct. This condition is common for both, but this is different. Their expectation is High Court judge. Here, any judicial office. Third point is not here. One point is common. Next, there we discussed about ad hoc judge, acting judge, retired judge. How about High Court? Here, acting judge concept is same. No need of discussion. If temporarily High Court Chief Justice is not there, another person will say that is a acting Chief Justice. No difference. But here, additional judge is there, not ad hoc judge. You need to understand by words. Ad hoc means you must understand Supreme Court judge. Here, the same thing is called as additional judge. Wordings to identify is different. The moment somebody is saying ad hoc judge means you must understand they are talking about Supreme Court. If they are telling additional judge, they are talking about High Court. You must be familiar with those things. Okay. So here also President will appoint. But here clearly term is mentioned. Only 2 years. If they are appointed for, they cannot be there more than 2 years. Is it clear? Again, purpose is same. That's what I'm saying. More work. Got it? So, arrears of work, pending work is there. And qualification must be matching. Only one thing is, everything is same. Word is different and 2 years is different. So, quickly, comparison. First comparison, Chief Justice of High Court. Second comparison, High Court look after below courts, but whereas Supreme Court look after not only below, but also tribunals. Okay, below and also tribunals. Third point, 25 High Courts, yes, combined is there. Next, homework is there for you. Next. Here also President. Appointment of judges is done by President. Only difference here, governor will be asked. Next,
Age.
retirement is 62, there it is 65. Sixth,
High Court judges. Supreme Court are practice.
ಮಾಡಬಹುದು. Yes. Don't have option. They cannot practice anywhere in India. 7. They can practice in London. They can practice in France. No problem.
Yeah.
Yes. 7th. Eligibility. 10 years of judicial office or 10 years of advocate in High Court. Judicial office anywhere. Next. Additional judge here to handle the extra work. But here 2 years tenure is given. Is it clear? So this completes Supreme Court, High Court. Can we finish in 5 minutes? The lower courts? One day page. Barkondru not even 5-6 slides. Notes ideo ilvo nange martogide. There is very small thing. If I don't think it is there. Lower courts. I don't think it is there. Polity ಒಂದು book ಇಟ್ಕೊಂಡಿಲ್ವಾ ನೀವು?
ನಾವು ಇದ್ರಲ್ಲೇ ಬರ್ತೀವಿ.
ಒಂದು book ಬೇಕು. So many additional things will be there. ನೀವು ವರ್ಕ್ ಮಾಡಬೇಕಾಗುತ್ತೆ. ಎಲ್ಲ ಹೇಳಿಸ್ಕೊತೀರಪ್ಪ. ಒಂದು ನೋಟ್ಸ್ ಅದಕ್ಕಾಗಿ ಸಪರೇಟ್ ಇಟ್ಕೊಳ್ಳಿಲ್ಲ ಅಂದ್ರೆ how you are going to handle ಅಂತೀನಿ. ಅಕ್ಕಿ ತರದ್ ಬೇಡ, ತರಕಾರಿ ತರದ್ ಬೇಡ, ಪ್ಲೇಟ್ ತರದ್ ಬೇಡ. ಆರ್ಡರ್ ಮಾಡು, ತಿನ್ನು, ಬಿಸಾಕು. ಅಷ್ಟೇ ಅಲ್ಲ?
ಮತ್ತೆ ಗೊತ್ತೇವೆ ನಾವು.
ನೋಟ್ ಸಪರೇಟ್ ಬೇಕು, ನಿಮ್ಗೆ ಗೊತ್ತಾಗಲ್ಲ. ಎಷ್ಟೊಂದು ಎಡಿಷನ್ ಆಗ್ತಾ ಹೋಗುತ್ತೆ. ನೀವು ಕೊನೆಯ ಎಕ್ಸಾಮ್ ಕ್ಲಿಯರ್ ಆಗೋವರೆಗೂ ಒಂದೇ ನೋಟ್ಸ್ ಅಲ್ಲಿ ಎಲ್ಲ ಬರ್ಕೊಳಂಗ್ ಇರ್ಬೇಕು. ಪಾಲಿಟಿ ಅಂದ್ರೆ ಒಂದು ನೋಟ್ಸ್. Okay. So High Court ಕೆಳಗೆ ಬಂದ್ರೆ which court you see? District Court. Below District Court? Taluk means Municipal Court we call. So have you heard about Sessions Court? Magistrate Court? ಕೇಳಿಲ್ವಾ? District Magistrate Court? ಕೇಳಿಲ್ವಾ? ಕೇಳಿಲ್ವಾ? ಸರ್ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಕೋರ್ಟ್ ಕೇಸಸ್ ಅಟ್ಲೀಸ್ಟ್ ಮೂವಿಗಳನ್ನಾರು ನೋಡ್ತೀರಾ ಅನ್ಕೋತೀನಿ, ಅದ್ರ ಬಂದೇ ಇರುತ್ತೆ. ಓಕೆ, ಸೊ ಹಿಯರ್ ಜಡ್ಜ್ ವಿಲ್ ಬಿ ಸೇಮ್ ಆಕ್ಚುಲಿ. ಇಫ್ he is handling criminal cases, he is called as what he is called as sessions judge. One is session, another is magistrate. If he is handling criminal cases, magistrate, or if he is handling normal case, sessions judge. Okay, sorry, first I said correctly. District judge or session judge. Person is only one. If he is handling criminal cases, got it? So then he is called as handling session court. If he is handling civil cases, property issues and all, he is called as district judge. Both are one only. District judge or session judge, only one person. What case to identify what case he is handling. Is it clear? So in district level is civil court and criminal court, if you want to say in normal word. Below that, obviously subordinate judge court will be there, and below that even municipal court will be there. Here for district level, chief judicial magistrate court, judicial magistrate court. Okay. So obviously district judge is the highest judicial authority in the district. So here, no, don't worry about all points, just which point you have to remember. Not like High Court and Supreme Court, you are going to study all those things. Okay. One is appointment of district judge. Okay. How the district judge will be appointed? What are the qualifications? Who will appoint him? Easily you can guess. Governor. We are within the state, no? So here for High Court and Supreme Court, President will appoint. Remember that. For district court, who will appoint? Governor. And he consult, obviously, High Court. So this will be your prelims question. These are all like who cannot become qualifications. Like if he is in a government service, definitely is not allowed. And minimum qualification is for 7 years, he must work as a advocate anywhere. No restriction, or pleader in higher courts itself. And High Court must recommend his appointment. And with respect to district judge appointment, okay, KPAC will be involving, means State Public Service. They will consult here. Karnataka means KPAC and High Court. In other state, State Public Service Commissions. And this is a normal point. Below whatever court is there, it will control them. Okay. Anyway, different type of judges names are used across India. Whatever you call, that is same only. District. For example, DC itself, how many times we call DC? District Collector, District Magistrate. Correct? No, different names are there. The same way here also, different names are there. No need to worry about that. Is it clear? And coming, when we are talking about a criminal case, no, already I discussed one case, death sentence case. Got it? They can give death sentence. But as I said, if they give death sentence, what High Court will do? They will take that case and check once. If they also accept, no problem. If they change it, no problem. If lower court says leave him and High Court says hang him, then Supreme Court will accept. So that is already discussed, that point. Okay. Yeah, that's it. So when we are talking about court system, no, we must talk about tribunals. We must talk about tribunals. Correct? Without that, it will be incomplete because they are also like part of the court system. So we'll discuss about tribunals. And later we'll discuss about Lok Adalats, because that is also working like a judiciary only. Got it? What is Lok Adalat? Kelidira? Kelidira, Kelilva? Lok Adalat. Hogli in TV, some shows will come, no? They will solve the disputes. Famous personality will sit and solve the dispute. Kelidira? Yaudo? Okay. Anyway, that is an official thing. So here, Lok Adalat. What is this? This is also like outside court. It is also solving the case. So Lok Adalat is important. Here, disputes at a pre-litigation stage. That means they are about to go to the court. What this Lok Adalat will do? Please come here. We'll separate the issue. Okay, land dispute is there. They are talking about. So this is my land. This is my land. So they will also give all the help, just like court. But here, compromise is the mode. So why you are fighting? How much? Sometimes what happens? No, that land worth will be 10 lakh. For 10 years, they have spent 20 lakh for that. For lawyers, in court terminology, means whenever somebody goes to court, no, what usually what is the common proverb? Court hodoro geddovanu sota, sotavanu satta. If he goes to court, if he wins, he's dead. Correct address. Because now I said, no, for 10 lakh property, he is spending 20 lakh. That's why he is loser. At least now he got some land. But other person lost money also, land also. That's why it is a dead person. So anyway, so Lok Adalats are there. What is the reason for Lok Adalat? Many cases are pending in courts. So they will tell the same thing. See, if you go to court for 10 years, 20 years, you will be fighting. Really, do you want to happen? Means make it happen? No, right? So we'll separate here itself. You give somewhat extra to him. They will listen. Simply, arbitrarily, they will not. Properly, they will listen everything. They will suggest. So better you give somewhat extra to him. Are you okay? So compromise. Go and live happily. Why you are struggling here? So pre-litigation stage. Okay. So they will. This is a win-win situation only. Compromise. Here, nobody is the winner and loser. Is it clear? So this is not something new to India. It's a old form of adjudicating system prevailed in ancient India. That's not it. Outside settlement, we know, right? In Taluk means Panchayat Katte. In movies, they will decide. Ur Gowda will sit and he'll give verdict. So that is same only. Kap Panchayat. Now also we'll see, which will be in news for bad things only. Their verdicts will be like irrational. Okay. So that Lok Adalat, since ancient times we are practicing. Name not Lok Adalat. In other form it is there. So they have given one popular name, Lok Adalat. Okay. Name itself says People's Court it is. And it is based upon Gandhian principles. And it's one of the components of alternate dispute resolution. Yes, this is not normal dispute resolution. Alternate dispute resolution. Alternate, other option now. Okay. The reason is simple. So small thing people are coming to court. Better to solve them outside only. Okay. So it is good, beneficial for everyone. For government, it is good. For judiciary, it is good. For only it is bad for liars. Here also liars are involved. But in one hearing, if it closes over now, if it happens in 10, 20 hearings, got it. So anyway, first in 1982, first Lok Adalat camp, that is just for information sake in Gujarat. Okay. But later it has become like popular everywhere. The Lok Adalat camps are being organized. So in 1987, formally that act was passed by parliament. Means legal status, statutory status. Yes, we will use Lok Adalat. So at means proper organized way. Means at national level, at state level, at district level, got it? Taluk level, everywhere, wherever court is there, simple words. Wherever court is there, pre-litigation. If somebody is coming to file the case, come here. We'll sit and solve. But here, both should agree. Is not ready, you cannot. Both should be ready. Then it is possible. Okay. You understood the concept, right? You can read on your own. Okay. Advantages, no need to explain. Everyone knows that it is less expensive, time consuming. Correct, no? Technicalities will be less. Time taken will be less. And here, no one is a winner and loser. Both are winner. So these are all the good points. One variation is there. One liner I'm saying. Permanent Lok Adalat. Lok Adalat is for everyone. For everyone. What is for permanent Lok Adalat? This is for whom? For example, you both are fighting, that is Lok Adalat. Permanent Lok Adalat is related to public utility services. For example, you are fighting with, it will be citizen, other side will be agencies. That is also important, no? Suddenly 10,000 bill is given by Bescom. Here also, instead of fighting in the court, they will go. It is very easy to solve actually. They will ask him, bring your all old 10 months current bills. So he will submit for every month he has paid 1,000. And this month suddenly 10,000 bill. They will say, do you want to fight for this? Immediately solve the case. Take 1,000 rupees and close the example. Maybe he might have used 2,000 on that month. But okay, nothing. Instead of fighting, closing case is good. Right? So it is related to public utility services. Permanent Lok Adalat. So government understood benefit of this Lok Adalat. It is helping so many people to solve the case easily. So why can't we set up a permanent Lok Adalat to solve the public utility services? Is it clear? See, examples like MTNL, Delhi Vidyut Board, same thing. Bescom. For them also it is very, very beneficial. Sir, actually, he has used 2,000 rupees, but only paying 1,000 rupees. Are you going to spend only 1,000 rupees to run the case? Instead, actually, forget about this 1,000. He will say that this month I will waive off everything. Please leave me. Cost is very high. Got it? For example, you have not paid 50 rupees your phone bill. Will they file case and why they will leave? To collect that 50 rupees, now they have to spend 5,000 rupees. Actually, more than that. That's why what they will say, leave it. Is it clear? But with respect to Lok Adalats and permanent Lok Adalats, one difference you need to remember. In the Lok Adalats, no, if both parties are not ready, they cannot take the case. But in this permanent Lok Adalat, no, the first stage is compulsorily they have to go here. Most of the cases, if it is very normal, they will solve here only. They will not allow it to go further. Okay. Next, I must talk about, because without these things, it will be incomplete judicial system. Famous court is family court. Everyone knows that. Family court. Since from 1984, see, Adalat from 87. From 84, family court separately. Why? See, high court is burden, court is burden. That's why they are segregating the things, reducing the burden. Family courts, always everything is fixed. Either harassment or divorce or adoption or children care. These are matters only, right? So that's why they did separately, mainly to marriage and family affairs. Is it clear? Okay. See, these are the matters. Only this much is enough. Everyone knows that. Like alimony, matrimonial relief, divorce happens. Okay. Nullity of marriage, divorce, reverse, joining them together back. Restitution of conjugal rights. They are separated. Now they are telling live together. Declaration as to validity of marriage. Sometimes giving, for example, live in relationship. Yes, this is a marriage only. Property of the spouse, either of them. How to distribute. Some issues will be there. For example, a husband might have taken some property and named it in the wife's name. Divorce happens immediately. So should he leave that property like that? So he will file the case. Okay, legitimacy fine. Guardianship, minor. Again, with respect to children, maintenance of anyone, even including parents. Old citizens need to be given relief. So all these cases are family court. I'm not spending too much time here because I can spend the same time like Supreme Court and High Court. But out of all these things, one question will come. You must read when it comes in news in detail. Gram Nyayalayas. So again, I'm telling you, I think whether if you know or don't know, I don't know. Discussion forum nobody is using. Make use of the facilities. Your answers will be given immediately there. That is like outside classroom, you are having support 24/7. Okay, don't put in midnight 2 o'clock. Sir, I did not get answer. Don't say like that. Actually, ultimate goal is that one only for that. 24/7, we should support our students. Immediately, if you put your question there, so means now at least within 1 day we'll answer. So you put your question there, doubts are there. Okay. So anyway, Grama Nyayalayas. Name itself is saying people are not coming, means it's very difficult for the rural people to come to cities and file their cases. So much expenditure. How about providing court in their own place? Means court is moving to their place, not setting up of court in every village. Costly it is. Cases will not be there. So what they will do for these 10 villages, today will be the court. They will go there and over. So it becomes easy for those people. Nearest villages, they will attend there itself. So since 2008, so courts at grassroots level got it at doorstep. Reason is simple. Is it clear? They cannot go to the same court it is going. Don't think that it is a separate court. Same court, but the cases are handled in their villages. Is it clear? Fine. When it comes in current affairs, we will discuss. Don't think that we will not discuss. If it is in news, then definitely we'll discuss in detail, or definitely you can go through them. Is it clear? And one more is tribunal. Tribunal, very important. Tribunals are very important because in water dispute and other cases, environmental issues, tax issues, wherever you go, tribunals are there. Till now, what we discussed, no, that is court system, except Adalat. Adalat is like a outside court settlement. Outside court settlement. Okay. So, what are these tribunals? This is court only. What is the difference then? How you would say that this is high court and this is tribunal? What is the difference? Only difference is here they are handling all the cases. They are handling particular cases. Sir, tax, only tax they will discuss. Sir, environment related, only environment related. Sir, water dispute, that too only Kaveri water dispute, not other dispute. Yes, only Kaveri water dispute. Is it clear? So, actually in original constitution, that was not there. It was not there. But the court cases were keep on accumulating, pending. They were not able to handle. They were not able to handle. So in such scenario, the 42nd Amendment added one 14th A part. Okay. So two articles, 323 and 323B, related to tribunals. Part is 14th A. Amendment, all are questions only, MCQs. 42nd Amendment, Article 323 and 323B. Okay. So, what is 323A and 323B? What is 323A and B? A is related to administrative tribunals. A is related to administrative tribunals. Okay. What do you mean by administrative tribunals? Tell me. Suppose tomorrow you become DC, some service matter will be there. Within 3 months, they transferred you to other place. Where you will go? You will go to tribunal, KAT, Karnataka Administrative Tribunal, administration related matters. So if it is wrong, they will cancel it. Your exam problem, means your answer is correct, but KPSC has given wrong answer. So where you will go for justice? KAT, administrative matters. Okay. So 23A talks about administrative tribunals. For example, central level CAT is there. Karnataka KAT is there. Central Administrative Tribunal, Karnataka Administrative Tribunal. Got it? So they are handling administrative matters. Got it? So Parliament has passed Administrative Tribunal Act in 1985 related to this. So Central Administrative Tribunals and State Administrative Tribunals. CAT is only one, but state-wise, Karnataka Administrative, all states are having their own tribunal. Okay. So about CAT. CAT is centrally located at Delhi. But it is having, because cases are, central government employees are not only in Delhi, right? So many branches are there. Okay. Actually 17, no need to remember, but they are handling in branches also. Is it clear? For example, your All India Service, Central Service, all are dealt by CAT. Even some are dealt by KAT also. The same way, state level, State Administrative Tribunal. Okay. So, presently we have 9 SATs. 9 SATs. Sir, there are many states, right? Union territories is easy because CAT is there. How about remaining states? Where they have to take the case? Say, in 9 states only we have. Correct, no? Remaining states, where they have to go? Forgetting the original one. Before tribunals, where they used to go? High Court. To reduce the burden of High Court, we are making new one. Is it clear? But interesting thing, no? Okay. To reduce the burden of High Court, they have made tribunals. But now people, what they are doing now? They are going to tribunal and again going to High Court. I am not satisfied with the tribunal verdict. What is this? To avoid burden, they have made. But people going again to High Court. One extra mechanism. And the burden is also transferring. This is one negative point you can remember. Okay. Some joint tribunals are also there. Okay. That's okay. Now, so you just remember, it may be big, but what you have to remember, 323A is for administrative matters, central administrative and also state administrative. Correct? 323B is related to what? Specific. Administrative as a whole, A over. B, almost all matters. For example, tax tribunal, land reform tribunal, food related tribunal. Got it? Tenancy right tribunal. Is it clear? So, these 3 points are enough. There, A is talking only about public service. B is talking about other matters. To abolish administrative tribunal under 323A, only Parliament can do it. Correct? But who can establish other tribunals? Both are capable. Means even Parliament can also make state also. Please remember these 3 points. I am telling MCQ will be given from here. Even mains question will be asked here. If you people show interest, if you write mains questions, I will discuss again all these questions. Means Gram Nyalaya, tribunals, because it is important from the mains point of view. If you write, I will discuss since means I am ready to put one more class for that. You have to write answers. Okay. So second point is, who can set up tribunal under 323A? Only Parliament. So under 323B, both Parliament as well as state, both can create. Okay. Next, third point. Under 323A, only one tribunal for the center and one for each state or 2 or more states may be established. Okay. But there is no question of hierarchy of tribunals under central. There is no hierarchy because only one word. No, don't worry about those 4 lines. Under central, there is only one. No hierarchy. This below this, below this. Sorry. But in 323B, you can create one by one. Okay. Earlier, the tribunals, no, whatever they said, that is final. But as I said, now they are going to Supreme Court and High Court. Because in Chandra Kumar case, they said that, yes, if they are not happy there, they can come here. And with respect to comparison, no, in tribunals, no, along with judge, one extra person will be there of a retired officer in that area. A tax officer will be there because he knows the tax matters easily. They can help him. Oh, this is how it is. Is it clear? So this is all about judiciary. So in last, I think 20-25 minutes, we covered Adalat, Permanent Lok Adalat, family courts, tribunals, Gram Nyayalas, tribunals. Okay. Don't think that just because we covered in 20-25 minutes, these are not important. From prelims point of view, idea is important. I have given. From mains point of view, one topic is like one question. About Gram Nyalaya, they can ask independent question. About which one? Tribunals, very powerful questions I am saying. Don't think that, okay, just because it's covered in small time. So other way around, which is important for prelims, no? Okay, in mains, not so important. They will ask, but whichever is left in prelims, no, that will be the potential question for mains. This is how this balance is there. You can easily see that in the question papers. Okay. So, any doubts here? Any doubts? Obviously, for everything, you can discuss like High Court and Supreme Court. Sir, who is a chairman, who is appointed, how they are going to be appointed. All those things are there. Okay, you need to do some homework. Okay. Yes, please answer. Third question. Sorry, something is wrong here. Under what circumstance can the Indian Supreme Court hear a case? If the case involves question of both law and fact. Another D is here. Yes, what is the answer? Online ಏನು ಮಾತಾಡಲ್ವಾ? Yes, please answer. C. ಎಲ್ಲರದು C ನಾ? Everyone says C. Question of? See, first thing, this is no. Okay. So we know that for law, definitely yes. But how about fact? Under what circumstance it can hear a case? Two things are there. One is that is talking about appeal, right? ಅರ್ಥ ಅಷ್ಟಂತ ಆಯ್ತಲ್ವಾ? ಅಪೀಲ್ ಅದು ಕೇಳ್ತಾರೆ. ಲಾ ಕಂಪಲ್ಸರಿ ಬಂದೇ ಬರುತ್ತೆ. ಫ್ಯಾಕ್ಟ್ ಬರಬಾರ್ದು ಅಂತ ಏನಾರ ಇದೆಯಾ? ಬರಬಹುದು. ಇಲ್ಲಿ ಇಂಟ್ರೆಸ್ಟಿಂಗ್ಲಿ ಕ್ಯಾನ್ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. ಕ್ಯಾನ್ ಅಂಡರ್ ವಾಟ್ ಸರ್ಕಮ್ಸ್ಟಾನ್ಸಸ್ ಕ್ಯಾನ್ ದ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹಿಯರ್ ಅ ಕೇಸ್ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. ಕ್ಯಾನ್ ಅಂತ ಬಂದಾಗ ಎಸ್ ಸಿ ಕೊಡಬಹುದು. ಬಟ್ ಮಸ್ಟ್ ಅಂತ ಕೊಟ್ರೆ ನೆಕ್ಸ್ಟ್ ಡಿ ಕೆಳಗಡೆ ಇದಾವೆ ಎಲ್ಲ, ಮತ್ತೆ ಮಿಸ್ ಮಾಡಬೇಡಿ. ಕ್ಯಾನ್ ದ ಇಂಡಿಯನ್ಸ್ disputes between private individual and organization. ಏನಾಯ್ತು? ಯಾಕೆ ಆನ್ಲೈನ್ ಯಾರು ಮಾತಾಡ್ತಾನೆ ಇಲ್ಲ? ಎ ಆರ್ ಸಿ. ಸಾರಿ, Can the Indian Supreme Court hear cases involving disputes between private individuals or organization? Okay. Obviously, yes, we know that. One or other way, they are not telling appeal or whatever, original or something. Yes, we can go. Supreme Court has jurisdiction over all civil and criminal cases. That is true. But only if the case involves a question of constitutional law. Not necessary. All. Okay. So if they're making it segregate like particularly appeal related or original something, then you can segregate. No, it is not like only this one. It can handle because as an appeal they can go right all civil and criminal cases. So answer is A, more appropriate. It is not like conditional. They are not telling that directly they are coming. No, correct. No, they might are appearing through appeal, High Court to Supreme Court, everything. Okay, but here, like this is very interesting thing. Can a appeal or civil or criminal case without certificate reach the Supreme Court? With certificate. Here, only if case involves a question of constitutional law, there. Whether it's a constitutional law or a civil law or a criminal law,
High Court to
certification is required. So, but they are highlighting only in case of constitutional law. Sorry. Is it clear? Okay. Can Indian Supreme Court review the decisions of the lower courts? So, ARC. ರಿವ್ಯೂ ಬಗ್ಗೆ ಮಾತಾಡ್ತಾ ಇದ್ದಾರ ಎನಾ ಸಿನಾ? ದಿಸ್ ಇಸ್ ಸಿ. ಏನ್ ಆನ್ಸರ್ ಕೊಟ್ಟಿದ್ದಾರೆ? ಎ. ಯಾಕಪ್ಪ? ನಾನು ಹೇಳಿದೆ ನಿಮಗೆ ಜುಡಿಷಿಯಲ್ ರಿವ್ಯೂ ಈಸ್ ರಿಲೇಟೆಡ್ ಟು ಲೆಜಿಸ್ಲೇಟಿವ್ ಅಂಡ್ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಆರ್ಡರ್ಸ್. ಓಕೆ, ಸೊ why it will review the lower court order? But again I can give another option. Final, this is like impossible. Appeal, why appeal is there? Supreme Court can only review the decisions of other high court. Sorry, yes, all the court they can review. Now here, whether is it the judicial power or is it related to constitutional law? Okay, so if you go technically, that's legislative and executive is fine. Judicial review is all about government only. When it comes to lower court, just we'll discuss this just for understanding sake. Only if case involves a question of constitution. I assume that there is no constitutional law. Suppose factual problem is there and district court has given something and high court has given something wrong only. Don't you think that Supreme Court will review it? Then in this case, it looks like C is also not 100% correct. Only in the case is constitutional law they are saying. But A I cannot say, B, D I cannot say. Only if the case involves question of constitutional law. But I say C is correct only. ನಿಮಗೆ ಡೌಟೇ ಬರ್ತಿಲ್ಲ, ನಾನು ಡೌಟ್ ಬರ್ಸಿ ನಾನು ಕೇಳ್ಬೇಕಾಗ. ವಾಟ್ ಈಸ್ ದ ಡೌಟ್ ಈಸ್
ಇವಾಗ ಜುಡಿಷಿಯಲ್ ರಿವ್ಯೂ
ಏನ ಸರಿ
ಅದಕ್ಕೆ ಜುಡಿಷಿಯಲ್ ಪವರ್ ಇಲ್ಲ.
ಪವರ್ ಇದೆ ಏನಾ ಸೀನಾ ಅಂತ? ಪವರ್ ಇದೆ ಎಲ್ಲಿದೆ ಅಂತ ಕೇಳ್ತಿದ್ದಾರೆ. See, that's what I'm saying. This is correct only, but I'm saying Supreme Court and review they are saying. Okay. For example, I'm going to appeal a case to the Supreme Court from the lower court. What they are doing? Is it review or they are hearing the case like freshly? fresh, right? But if it is involving constitutional matters, definitely it will review. So, there are two components. So they are asking about review. Yes, review is only done for this. Okay. Next, can Supreme Court hear appeals from High Court? Again, no, easily will be remove it. Correct, no? No, Supreme Court can hear appeals from District Court. No, Supreme Court does not have jurisdiction over appeals from High Court. In ಯಾವ ಕೋರ್ಟ್ ಕೊಡೋದ್ರಿಂದ. Yes, ARC. ARC. It's straightforward. Yeah, only. Not necessary, because we discussed appeal, constitutional, civil, everything. All appeals, including special leave petition. Okay. Next. Yeah. Can Indian Supreme Court ಉಳಿದು ಆನ್ಲೈನ್ ಅಷ್ಟೊಂದು ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ. ನಾನು ಎಕ್ಸ್ಟ್ರಾ ಇಂಟ್ರೆಸ್ಟ್ ತಗೊಂಡು ಈ ತರ ಕ್ವಶನ್ಸ್ ತಗೊಳ್ಳೋದು ಬಿಟ್ಬಿಡ್ತೀನಿ. You must actively participate, right? Can the Indian Supreme Court hear appeals from Military Court of Appeals? So answer now here is BRD. Yes ಅನ್ನೋದು ಇಲ್ವೇ ಇಲ್ಲ. ಯಾವ ಕೇಸಲ್ಲೂ ಮಿಲಿಟರಿ ಕೋರ್ಟ್ ಇಂದ ಅಪೀಲ್ ತಗೊಳಂಗೇ ಇಲ್ಲ. ಎಸ್ ಇಸ್ ರಾಂಗ್. ಓದೋಕಿನ ಮುಂಚೆನೆ ರಾಂಗ್ ಅದು. ಓಕೆ, ಸುಮ್ನೆ ಏನ್ ನೋಡಿ ಚೆನ್ನಾಗಿ ಕ್ರಿಯೇಟ್ ಮಾಡ್ತಾರೆ. jurisdiction over all appeals from Military Court of Appeals ಸ್ವಲ್ಪ ದೊಡ್ಡದಾಯ್ತು. ಬಟ್ ಓನ್ಲಿ ಇಫ್ ಕೇಸ್ ಇನ್ವಾಲ್ವ್ಸ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಅಲ್ಲ, ಸುಮ್ನೆ ನಿಮ್ಮನ್ನ ಟ್ರ್ಯಾಪ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಓ, ಸ್ಪೆಷಲ್ ಒಂದು ಕೇಸ್ ಇರಬಹುದು ಅಂತ. ಓಕೆ, no, the Military Court of Appeals is highest court for the military cases. Supreme Court does not have jurisdiction over appeals from the Military Court of Appeals, which is correct. Dina, D is correct. Got it. It don't have the jurisdiction over appeals from the Military Court of Appeals. D is correct. Easy ಇದ್ರು ಅದರಲ್ಲಿ ತಪ್ಪು ಮಾಡ್ತಿದ್ದೀರಾ ನೋಡಿ. jurisdiction ಇಲ್ಲಮ್ಮ. ಹಾ, ಬಿ ನಲ್ಲಿ ಮಿಲಿಟರಿ ಕೋರ್ಟ್ ಆಫ್ ಅಪೀಲ್ಸ್ ಅಂತ ಎಕ್ಸ್ಟ್ರಾ ತಗೊಂತಿದ್ದಾನ, ಅಲ್ಲಿ ಇಲ್ಲದೆ ಇರೋದನ್ನ. ಸೊ ಡಿ ಇಸ್ ಕರೆಕ್ಟ್. ಕ್ಯಾನ್ ಇಂಡಿಯನ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇಶ್ಯೂ ಅಡ್ವೈಸರಿ ಒಪಿನಿಯನ್ಸ್? ಸೊ ಎರಡು ಆಪ್ಷನ್ ಹೋಗ್ಬಿಟ್ಟು ಸುಮ್ಮನೆ ಇಂಟ್ರೆಸ್ಟಿಂಗ್. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಕ್ಯಾನ್ ಓನ್ಲಿ ಇಶ್ಯೂ ಬೈಂಡಿಂಗ್ ಡಿಸಿಷನ್ಸ್. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಡಸ್ ನಾಟ್ ಹ್ಯಾವ್ ದ ಪವರ್ ಟು ಇಶ್ಯೂ ಅಡ್ವೈಸರಿ. ರಾಂಗ್. ಓಕೆ, ARC. Supreme Court can issue advisory opinions at the request of President or Parliament, but only if the case is a question of constitutional law, which is correct. ಇದನ್ನು ತಪ್ಪು ಮಾಡ್ಬೇಡ್ರಿ, ಹಂಗೆ ಹೇಳ್ಕೊಟ್ಟಿದ್ದೀನಿ ನೀಟಾಗಿ. ARC ಆನ್ಲೈನ್ ಅವ್ರು ಎಲ್ರು ಆಕ್ಟಿವ್ ಆಗಿ ಆಗ್ತಾ ಇದಾರೆ. ಎಸ್, ಎ ವೆರಿ ಗುಡ್. ಎ ತುಂಬಾ ಕ್ಲಿಯರ್ ಆಗಿದೆ. ರಿಕ್ವೆಸ್ಟ್ ಆಫ್ ದ ಪ್ರೆಸಿಡೆಂಟ್ ಆರ್ ಪಾರ್ಲಿಮೆಂಟ್. ಹಿಯರ್ ಇಲ್ಲೇನಿದೆ, ಓನ್ಲಿ ಇಫ್. ಯಾರು ಹೇಳಿದ್ರು? ಈವನ್ ಪ್ರೀ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಕೇಸಸ್ ಕೊಡ್ತಾ ಇದಾರೆ. ಬರೀ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಯಾಕೆ ಟ್ರಾಪ್ ಮಾಡ್ತಾ ಇದ್ದಾನೆ? ನೆಕ್ಸ್ಟ್, ದಿಸ್ ಈಸ್ ಇಂಟ್ರೆಸ್ಟಿಂಗ್. ಕೇಸ್ ಇನ್ವಾಲ್ವಿಂಗ್ ಇಂಟರ್ಪ್ರಿಟೇಷನ್ ಆಫ್ ಇಂಟರ್ನ್ಯಾಷನಲ್ ಲಾ. ದಿಸ್ ಸಮಥಿಂಗ್ ನ್ಯೂ. ನೋಡಿ ಹೇಳಿ, ಯೋಚನೆ ಮಾಡಿ ಹೇಳಿ. ಆನ್ಲೈನ್ Supreme Court jurisdiction over all cases involving interpretation of international law? No. Supreme Court has domestic law. Case involves a question of constitutional law? No, the Supreme Court does not have jurisdiction over cases involving the interpretation of institutions. Yes, ಏನಮ್ಮ? Supreme Court has jurisdiction over all cases involving the interpretation of the international law. C. Why C? Why C? I want to do homework for this because this is important. ನಾನೀಗ ಆನ್ಸರ್ ಹೇಳ್ಬಿಟ್ರೆ ನೀವು ಮತ್ತದ್ ಮಾಡಲ್ಲ. ಅದೇ ಹೋಮ್ವರ್ಕ್ ಮಾಡಿದನಂತ ನಾನು ಆನ್ಸರ್ ಹೇಳಲ್ಲ. ಆನ್ಸರ್ ಹೇಳಿದ್ರೆ ಯಾಕೆ ನೀವು ಹೋಮ್ವರ್ಕ್ ಮಾಡಲ್ಲ? ಐ ವಾಂಟ್ ಆನ್ಸರ್ ಫಾರ್ ದಿಸ್. ನಾನು ಹೇಳಿದ್ರೆ ನೀವು ಹೋಮ್ವರ್ಕ್ ಮಾಡಲ್ಲ. ಇದಕ್ಕೆ ಹೋಮ್ವರ್ಕ್ ಮಾಡಿ ಇದನ್ನ ನೀವೇ ನೆನಪು ಮಾಡಿ ಕೇಳ್ಬೇಕು, ನಾನು ಆನ್ಸರ್ ನೆಕ್ಸ್ಟ್ ಕ್ಲಾಸ್ ಅಲ್ಲಿ ಬರ್ಕೊಡಿ. ಕ್ವಶನ್ ಬರ್ಕೊಳ್ಳಿ ಸಾಕು, ಆನ್ಸರ್ ಅದು ಆಮೇಲೆ ನೀವು ಮಾಡ್ಕೊಂಡು. ಆಪ್ಷನ್ಸ್ ಆರ್ ನಾಟ್ ಇಂಪಾರ್ಟೆಂಟ್. ಓಕೆ, ದಿಸ್ ಇಸ್ ಹೋಮ್ವರ್ಕ್. Next, can the Indian Supreme Court hear cases involving disputes between states? ಗೊತ್ತಿದೆ ನಮ್ಗೆ, ಒರಿಜಿನಲ್ ಅಲ್ಲೇ ಇದೆ. ಅದರಲ್ಲಿ ಎಸ್ ನೋ ಎಸ್ ಎಸ್ ಗಳು ಎರಡಿದಾವೆ. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆಫ್ jurisdiction all cases involving dispute between states. ನೆಕ್ಸ್ಟ್ ಇನ್ನೊಂದು ಎಸ್ ಇದೆ ಅಲ್ಲ, dispute between central government and state government. ಯಾವ್ದಪ್ಪ ಅನ್ಸ ಇನ್ನು ಮುಂದೆ ಎಸ್ ಓನ್ಲಿ ಇಫ್ ಕೇಸ್ ಇನ್ ಆಲ್ ಕ್ವಶನ್ ಆಫ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್. ಇಲ್ಲಮ್ಮ, ಹೌದಾ? ಆಗ್ಲಿ ಬಿಡಿ, ಅಲ್ಲಿ ಆನ್ಸರ್ ಹೇಳಿ ಹಂಗಾರೆ. ಇದಕ್ಕಿನ್ನ ಗೊತ್ತಿದೆ ನಿಮಗೆ, ದಟ್ ಇಸ್ ಒರಿಜಿನಲ್. ಇಟ್ಸ್ ಓಕೆ, ನೋ ಪ್ರಾಬ್ಲಮ್. ಆಪ್ಷನ್ ಮಿಸ್ ಇದೆಯಾ? ಕ್ಯಾನ್ ಇಂಡಿಯನ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಕೇಸ್ ಇನ್ ಆಲ್ ಡಿಸ್ಪ್ಯೂಟ್ ಬಿಟ್ವೀನ್ ಸೆಂಟ್ರಲ್ ಅಂಡ್ ಸ್ಟೇಟ್ ಗವರ್ಮೆಂಟ್? ಅಲ್ಲೇನು ಟ್ರಿಕ್ ಇತ್ತು ಅಂದ್ರೆ ಅದೇ ಕಮರ್ಷಿಯಲ್ ನೇಚರ್ ಎಲ್ಲ ಅಂತ ಕೊಟ್ಟಿದ್ನಲ್ಲ, ರಾಂಗ್ ಅದು. ಇನ್ನೆರಡು ಆಪ್ಷನ್ ನಾವು ಮಿಸ್ ಆಗೋಗಿದೆ ಅಲ್ಲಿ, ಗೊತ್ತಾಯ್ತಲ್ಲ? ಸೊ ಆಲ್ ಅಂತಾನೆ ಸುಳ್ಳು. ಓನ್ಲಿ ಸ್ಟೇಟ್ ರಿಲೇಟೆಡ್ ಮ್ಯಾಟರ್ಸ್ ಹೊರತು ಪೊಲಿಟಿಕಲ್, ಕಮರ್ಷಿಯಲ್, ವಾಟರ್ ಡಿಸ್ಪ್ಯೂಟ್ ಅವೆಲ್ಲ ಇಲ್ಲ. ಅದನ್ನ ಚೆಕ್ ಮಾಡಕ್ ಅಲ್ಲಿ ಇತ್ತು ಅದು ಕ್ವಶನ್. ಇರ್ಲಿ, ದಿಸ್ ಒನ್ ಸೆಂಟ್ರಲ್ ಅಂಡ್ ಸ್ಟೇಟ್ ಗವರ್ಮೆಂಟ್ ಡಿಸ್ಪ್ಯೂಟ್. ಹೆಂಗಮ್ಮ? ಸೀನೋ ಅಲ್ಲ, ಇಲ್ಲಿರೋದ್ರಲ್ಲಿ ಎಸ್ ಇರೋದ್ರಲ್ಲಿ ಏನೇ, ಬಟ್ ಈಗ ನಾ 100% ನಾಟ್ ಸ್ಯಾಟಿಸ್ಫೈಡ್. ಯಾಕೆ ಅಂದ್ರೆ ಯು ನೋ ದ ಎಕ್ಸೆಪ್ಷನ್ಸ್. ಹಿಯರ್ ಇಟ್ ಇಸ್ ಸೇಯಿಂಗ್ ದಟ್ ಆಲ್ ಕೇಸಸ್ ಅಂತ ಕೊಟ್ಬಿಟ್ಟ. ಬಟ್ he is not talking about original jurisdiction. That's why A is correct. Here one word is added, means original means ಯಾವ್ದು ರೈಟ್ ಇಲ್ಲ. So it may be political, it may be commercial. Some comes under original, some comes right, some comes under advisory, some comes under appellate. That's why this is correct. ನೋಡಿ, ಒಂದು ವರ್ಡ್ ಅಲ್ಲಿ ಕ್ವಶನ್ ಎಲ್ಲಿ ಬೇಕಲ್ಲಿ ಕಳಿಸ್ಬಿಡಬಹುದು. ಅರ್ಥ ಆಗತ್ತಲ್ಲ? ಕರೆಕ್ಟ್. ನೆಕ್ಸ್ಟ್ ಅಂದ್ರೆ ನೋಡಿದ ತಕ್ಷಣ ಏನ್ ಅನ್ಸುತ್ತೆ, ಇಲ್ವಲ್ಲ ಅಂತ. ಹಿ ಇಸ್ ನಾಟ್ ಆಸ್ಕಿಂಗ್ ಅಂಡರ್ ಒರಿಜಿನಲ್. ಇಫ್ ಯು ಆಸ್ಕ್ ಅಂಡರ್ ಒರಿಜಿನಲ್, ಗೊತ್ತಾಯ್ತಲ್ಲ, ಅವಾಗ ಯಾವುದು ಸರಿ ಹೋಗಲ್ಲ ಅಲ್ಲಿ. Can Indian Supreme Court hear cases in a dispute between two or more state governments? No, ಎರಡು ಬಿಟ್ಬಿಡಿ. ಏನೇ, he is not asking under which. Can Indian Supreme Court hear case in a dispute between state government and foreign government? ಇದನ್ನ ಹೋಮ್ವರ್ಕ್ ಅಲ್ಲೇ ಇಟ್ಕೊಂಡಿರೋಣ. ಅದೇ ಕ್ವಶನ್ ಇದೆ, ಇನ್ನೊಂದು ಪಾರ್ಟ್. ನೀವು ಅದನ್ನ ಮಾಡ್ತಾ ಮಾಡ್ತಾ ನಿಮ್ಗೆ ಇದಕ್ಕೂ ಆನ್ಸರ್ ಗೊತ್ತಾಗುತ್ತೆ. ನೆಕ್ಸ್ಟ್, again ಸೇಮ್ ಅದು ಸ್ಟೇಟ್ ಹೇಳಿದೆ ಸೆಂಟ್ರಲ್ ಗವರ್ಮೆಂಟ್ ಹೇಳಿದೆ. ಹಾ 2 or more ಫಾರಿನ್ ಗವರ್ಮೆಂಟ್ಸ್ ಮಾಡ್ಬೋದಾ? ಗೆಸ್ ಮಾಡ್ತೀರಾ? ಎರಡು ಫಾರಿನ್ ಗವರ್ಮೆಂಟ್ ಇಂದು ನೇಪಾಳ ಭೂತಾನ್ಗೆ ಎರಡು ಫೈಟ್ ಮಾಡ್ಕೊಂಡು ಬಂದಿದ್ದಾವೆ. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹ್ಯಾಂಡಲ್ ಮಾಡ್ಬೋದಾ? ನೋಡೋಣ. ಇದನ್ನ ಯಾಕಂದ್ರೆ ಒಂದೇ ಟಾಪಿಕ್ ಇಂದ ಅವು ನಂಗೆ ಆಮೇಲೆ ಆನ್ಸರ್ ಹೇಳಿ. ಎಲ್ಲ ನೆಕ್ಸ್ಟ್ ಕ್ವಶನ್ ಆಯ್ತಲ್ಲ ಇದು. ನೆಕ್ಸ್ಟ್ ಇದು ಹೇಳಿ. ಪ್ರೈವೇಟ್ ಇಂಡಿವಿಜುವಲ್ಸ್ ಆರ್ ಆರ್ಗನೈಸೇಷನ್ ಡಿಸ್ಪ್ಯೂಟ್ಗಳನ್ನ ಕೇಳ್ಬೋದಾ? ಈಸಿ ಇದೆಯಲ್ಲ, ಇದ್ರಲ್ಲಿ ಏನಿದೆ? ಸೊ ಕ್ಯಾನ್ ದೇ ಹಿಯರ್? ಎಸ್, ಬಟ್ ಇದೆಲ್ಲ ಇದೆ ಸಿ ಆತರ ಏನಿಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಎಸ್ ಇದು ಹೇಳಿ. ಬಿಟ್ವೀನ್ ಇಂಡಿವಿಜುವಲ್ ಅಂಡ್ ಗವರ್ಮೆಂಟ್ ಹ್ಯಾಂಡಲ್ ಮಾಡ್ಬೋದಾ? ಎಸ್, ರಿಟ್ ಅಲ್ಲ. ದೇ ಆರ್ ನಾಟ್ ಆಸ್ಕಿಂಗ್ ಒರಿಜಿನಲಿ. See, yes, A only. Okay, fine. So that you homework ಮಾಡಿ. ಇಲ್ಲಿವರೆಗೂ ಬಂದಿಲ್ಲ ಅದು ಕ್ವಶನ್, ಪ್ರಿಲಿಮ್ಸ್ ಕೇಳಿಲ್ಲ ಆತರ. ಸೊ ಅದನ್ನ ಕೇಳ್ಬೋದು. ಅಂಡ್ ಒಂದು ಮೋಡ್ ಅರ್ಥ ಆಗಿರ್ಬೇಕು. ಯೂಶುವಲಿ ಜ್ಯೂರಿಸ್ಡಿಕ್ಷನ್ ಯಾವ್ದ್ರ ಮೇಲಿದೆ ಅಂತ. ನಾ ಇಲ್ಲಿನೂ ಇದು ಜನರಲ್ ಆಗೇ ಐತಲ್ಲ ಅದು, ಬಟ್ ಪರ್ಟಿಕ್ಯುಲರ್ಲಿ ಕೇಳ್ತಾನೆ. ಲಾಸ್ಟ್ ಅಬೌಟ್ ಒರಿಜಿನಲ್ ಜ್ಯೂರಿಸ್ಡಿಕ್ಷನ್. ಆಯ್ತಾ? ಸೊ ವಿ ವಿಲ್ ಟೇಕ್ ಫ್ರಮ್ ಇದು ಟಾಪಿಕ್ ಎಲ್ಲಿ ಇಟ್ಟಿದೀವಿ. ಓಲ್ಡ್ ಕ್ವಶನ್ ಪೇಪರ್ ನೋಡೋಣ. ಅಲ್ಲ, ನೀವು ಟೆಸ್ಟ್ ಬರೀತೀರಲ್ವಾ ಹೆಂಗು? ಈಗ ನಾಳೆ ಇದೆಯಾ? ನಾಳೆ ಇಲ್ವಾ? ಹೇಳಿದ್ನಲ್ಲ ಮುಂಚೆನೆ. ಓಕೆ, ಅಲ್ಲ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ದು ನಾಳೆ. ಯು ರೈಟ್ ದ ಅಸೈನ್ಮೆಂಟ್ ಪ್ಲಸ್ ಟೆಸ್ಟ್. ಅದು 100 ಮಾರ್ಕ್ಸ್ ಸಿಗಲ್ವಾ? ಓಕೆ, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಮಂಡೇ ಬರೀತೀರಾ? ನಾನು ಹೇಳೋದು ಸ್ಮಾಲ್ ಇದೆ ನೋಡಿ. ಎನಿ ಟೈಮ್ ಯು ಜಸ್ಟ್ ಆಸ್ಕ್. ನೀವೇ ಕೇಳ್ಬೇಕು ಇವಕ್ಕೆಲ್ಲ ಸ್ಮಾಲ್ ಬರೀ. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಸೈನ್ಮೆಂಟ್ ಬರೆದು ಟೆಸ್ಟ್ ಬರೀರಿ. See, questions will be less, 20, 30. It won't take more time. But for 100 questions, no, you must have proper 2 hours time. So ಅದಕ್ಕೆ ಹೇಳ್ತೀನಿ. Tomorrow you write Supreme Court, High Court and other judicial assignment. And also my suggestion is write test. If not tomorrow, at least Monday by 5 o'clock, you write test. From 5:30 you can attend class. ಅಲ್ಲ, ಅಸೈನ್ಮೆಂಟ್ ಟುಮಾರೋನೆ. ಟೆಸ್ಟ್ half an hour ಟೆಸ್ಟ್. half an hour ಬೇಡ. you ask and write the test. ಸರಿನಾ? Is it clear? See, more you practice assignment test, automatically ಏನೇ ಮಿಸ್ ಆಗಿದ್ರು ಗೊತ್ತಾಗ್ಬಿಡುತ್ತೆ. Here itself you will learn the things. Any doubts? Okay. ಸೋಮವಾರದಿಂದ ಎಲ್ಲರೂ ಕರೆಕ್ಟ್ ಆಗಿ ಬರ್ತಾರಾ? Huh?